Honor. Welcome. We're here for the conference that I scheduled. This is case number NEPR-AP-2023-0003. I issued an agenda yesterday that I assume everybody has, and we'll get right into it. Before I get started, can I get Ms. Valle up, please? Ms. Valle, where are you? And where is Herneda's counsel? If you could also show yourself, please. Okay, good afternoon, ma'am. Are you Herneda's counsel, and what is your name, please?
Yes. Hi, my name is Attorney Maralis Vasquez. I'm counsel for Herrera.
Thank you. Shall I refer to you as Ms. Vasquez?
Yes, please.
Okay, thank you. And Ms. Valle, are you joining us today? Or is there somebody else for PREPA? Okay, I don't see her on my, let's see. Ms. Valle, talk to me.
I'm here. I'm having some trouble connecting, but I'm here.
Okay, thank you.
Good afternoon, everyone.
I think we might have a echo. Let me see, Ms. Valle, tell me when you're ready, please. There we go.
I'm here.
Welcome. How you doing, Ms. Valle? Okay, you just muted yourself now. Unmute yourself.
Okay.
Okay.
Can you hear me?
Okay. Thank you. Thank you. I read what you sent just a few minutes ago. So everybody relax. This is what I hope to do. Okay. I think I can make this go away. I'm not going to ask anybody to, and I never do, prejudice their rights or anything else, Ms. Valle. But what I want to ask you to do, if you can, I'm not going to make you do it, okay? But if you can, see if you can get your CFO here, and I think, or we can take a break and get the person here. I want to ask a few questions. If I ask a question that you don't want them to answer, you just say I don't want them to answer. I'm not going to put you in a position where you didn't have a chance to make the arguments you want to make. I want to try to avoid your having to file a pleading tomorrow or whenever the thing is due. Okay, I think I can make this go away. And that was my only intent. So that's all I want to say for now. I'm asking you to see if you can get your CFO here, because I think that person might be able to solve the problem. And again, you'll listen to my questions. And if you think there's something I'm asking that you don't want the person to answer, you just tell me and we'll deal with it. So you do the best you can. Okay, Ms. Valle?
Yes, sir. The only thing I want to inform is that presently, PREPA only has a controller. It doesn't have a CEO, a CFO. Okay. Apologies.
All right. Well, let me just ask you this. Is there anything that the CEO would know about this matter that the controller does not know? Or is the controller, you think, in possession of full knowledge of this matter?
He was in possession. He inquired on the matter and did a reasonable search before we submitted the response.
Okay, well, the question, just so that we're clear, is whether he looked everywhere. So my question to you is he the person who would be able to confirm that, Ms. Valle?
He is the one, yes.
Okay, well, if you can get him here, I think we can make this go away. I'm not going to take anything away, Ms. Vasquez, from what you want to argue. Okay, but I want to see if I can just save everybody one more pleading they have to file. Okay, and get this case going. So, Ms. Valle, do the best you can, and we'll see. And I would expect probably in a half hour, if we proceed quickly, we'll be able to use the person, or you can just tell him to be, on call, and we'll take a short break before we get to that point. Okay, Ms. Valle?
Understood. So in terms of the agenda, that's going to be one of the last points, correct?
Exactly. And so he doesn't have to hang around until then. Okay, Ms. Valle? Ms. Mercado, you're not going to you're not going to add anything to this, are you? Or you just for showing up so I could see you? Okay, yeah, you should stay out of this bar fight. Okay, very good. Does anybody, I'm glad we're all smiles. You can see I'm smiling too. Mr. Gonzalez, nice to see you too. Okay, let's get busy here. Let's go through our questions. Like I said, we've got Appendix A. in the document I issued. Now, I want to make another point before we get started, before I turn this over to Mr. Ralph Smith, our consultant. Perhaps I was not clear, and for that I apologize. What I intended for this oral discussion is that we have the types of questions that are seeking clarification of how this filing that was made the other day on revenue requirement is structured, where the numbers came from. I wasn't intending to make this a discovery session because discovery is most efficiently conducted on the platform. We'll go through the questions that are here, but if we get to a point where the answers can't come quickly and clearly, and therefore really need the platform, I'm just going to shut it down and we'll go to the platform. I just want to make sure that everybody leaves today understanding the document. That was the purpose. Is that okay with you, Ms. Mercado?
Yes.
Yeah, I'm just trying to minimize everybody's work today. Okay, Ralph Smith, our consultant, I'm going to turn it over to him and I'm going to go silent and he'll go through. Oh, I have a question first. I think this may be a question for you, Ms. Valle. It may be a question for Ms. Mercado. I've never quite understood who actually pays mechanically the FOMB costs. Is it a payment that PREPA makes to FOMB, Ms. Valle? Do you know, or is it a payment that Luma makes, Ms. Mercado? Starting with you, Ms. Valle, do you know?
Let me confer a quick second just to confirm that I'm going to give the correct answer.
All right, all right, I'll wait. Because I think that will affect to whom Mr. Smith directs his questions. By the way, Ms. Mercado or Ms. Chambers, who is going to be explaining the spreadsheet that you filed? Will it be one of you or will it be one of your people? Ms. Chambers, I just lost Ms. Mercado. Hold on, one at a time. Okay, Ms. Mercado, go ahead.
Sorry, I was conferring internally. I think you were asking who's gonna take the lead in the session. It would be mainly between Alejandro Figueroa, Chief Regulatory Officer, and Mr. Andrew Smith.
Okay. All right. We'll come to them in a second. Ms. Valle, what do you know about my question?
The payment, it's made by Hacienda, Puerto Rico Treasury Department, and then PREPA obtains a reimbursement of the payment.
So the payment comes out of a PREPA bank account? I'm sorry, I don't think I understood that. Does the payment come from a PREPA bank account?
No, it comes from an account from the Puerto Rico Treasury Department.
Okay, well then what's PREPA's involvement in this? When you say PREPA gets reimbursement, why would PREPA need reimbursement if the payment is not coming out of a PREPA bank account?
Give me 1 second.
Okay. Again, this is also that Mr. Smith knows whom to ask his questions of.
Okay, now I got it wrong the first time. Apologies. So
Please.
The Puerto Rico Treasury Department makes the payment, and then PREPA reimburses the Puerto Rico Treasury Department for the payment.
Oh, okay, that's extremely clear. So I assume from what you just said that the legal relationship that ensures the payment to FOMB is a legal relationship between the Treasury Department of the government and the FOMB. Is that your understanding?
Apologies, it got, I could not hear you well. Could you please repeat your question?
Of course. My inference from what you just said is that the Treasury Department of the Commonwealth makes that payment because it is legally obligated to, so there must be a contract between the government and the FOMB mandating that payment, and then the way that the ratepayers become responsible for it is that PREPA reimburses the Treasury Department, and it's the fact of PREPA's reimbursement that necessitates the costs going into the rates. That's my understanding. Do you want to check that during a break?
Yes, let me confer here to see if I can get you a quick response.
Okay.
If not, I will inform whether I need a break.
All right. Thank you.
Okay. So to the best of our knowledge, there's no contract between FOMB or the Puerto Rico Treasury Department. It's more of a statutory obligation, which arises from PROMESA.
Okay, excellent. That's as clear as it can be. Let me say it back to you to make sure I and my colleagues understand it. The legal basis for the obligation of the Commonwealth to pay the FOMB costs comes from the preemptive effect of the PROMESA statute. The obligation of the customers to include the FOMB costs in the rates is a result of PREPA becoming obligated to reimburse the Commonwealth for these costs. That's what I understand so far. Now I'm wondering, where is the obligation of PREPA to reimburse the Commonwealth? Is that a contract? Do you know, Ms. Valle? Because the reason I'm asking is the final order of the PREB of the Bureau has to explain why it is that the customers are paying this money. And so I want to make sure we have a clear understanding of the legal relationships. Ms. Valle.
I believe it is also a statutory obligation, but let me confirm if there is any contractual obligation as well.
Okay, all right. And then we'll go to Mr. Figueroa and Mr. Ralph Smith. So if Mr. Figueroa can arrive and Mr. Smith can show their videos, we'll be ready to go. Maybe I was the only one in the room who didn't know what we just learned, but now I am. Okay, well, we're going to get started. Maybe to be polite to Ms. Valle, I'll wait. So 1 second, Mr. Figueroa. Nice to see you today. You're muted, so, okay. And how are you enjoying let's see, your job is not so new anymore. Maybe I shouldn't be asking you under oath. Well, you're not under oath, how you're enjoying it, but I know that you and your folks are working very hard, as are all the other parties, and I appreciate it. All right, so we're just going to wait for Ms. Valle. By the way, Mr. Figueroa, yes,
so
Ms. Valle. Yes? Yes, ma'am?
Apologies for interrupting. I confirm, and it is a statutory obligation. There's no contract. PREPA has an obligation as a covered instrumentality under the PROMESA Act.
To reimburse the Commonwealth for the Commonwealth's obligatory payments to the FOMB, is that correct?
That's correct, yes. Because the primary, let's put it this way, the primary responsible party is the government of Puerto Rico. And PREPA, as a covered instrumentality, then has the obligation to reimburse.
Okay, well done, Ms. Valle. That was what I wanted to know, and now you've laid it all out. So if that changes, if your understanding changes, please let us all know. Okay, Mr. Smith, Mr. Figueroa, you're on. Thank you.
Hi, my name is Ralph Smith. We did have some questions to try to understand better some of the items that were added into the rate filing in the latest filing by LUMA. The Schedule C2 line 42 and 41 items are, I think, where we're going to start. Mr. Hempling had sent out a bunch of questions previously, so hopefully the parties were able to do a little bit of research and have answers for those. So let's start with the 51.289 million line 42 item for the 2026 fiscal year. Has any of that been spent to date?
So maybe as we just discussed right now, those are costs that are paid by PREPA, and according to the statements just made, paid by the Commonwealth and reimbursed by PREPA. So that question I respectfully request be directed to PREPA.
All right, and Mr. Smith, I think what we're going to do with this is that I'm going to assume, and Ms. Valle, you tell me if I'm wrong. I'm going to assume that all the questions that get moved by Mr. Figueroa to PREPA are questions that you're not going to be able to answer right away. And I don't want to interrupt, 7 times to find out the answers. So we're just going to move on, get the questions out there. Ms. Valle, you make sure you understand the questions. If not, you'll ask Mr. Smith to clarify them, and then we'll agree on a deadline by which you submit the answers. Is that okay with you, Ms. Valle?
Yes.
Okay, Mr. Smith, continue, please.
Okay, we were also trying to get clarity on how much of the 51.289 million is a direct request from the FOMB. Does anybody have the answer to that one?
What I could actually the all of the costs are so that is the amount or estimated amount of costs provided by the FOMB to us. So our understanding is that is their entire component. But other than that, we do not have any other breakdown on what built that number.
Okay, and then the 27.45 million on line 41. How much of that is a direct request from the FOMB?
That would be the distinction between line 41 and 42. Line 41 is the FOMB related cost, and those are FOMB costs incurred by the FOMB. Line 41 is PREPA restructuring in Title III. So that comprises both PREPA's internal costs related to its Title III proceedings, as well as what we refer to as LUMA's interim costs, which are the costs that LUMA incurs in connection to supporting PREPA's Title III proceedings. Out of the 27.45 million in that line, what's the amount? It's at 8.75. 8.75 out of the 27.45 million is LUMA interim costs. The remainder of those costs would be PREPA costs provided by PREPA.
Okay, so let me make sure we're clear on our understanding. So line 42 is all FOMB costs that the FOB is incurring, and then line 41 is the LUMA and PREPA costs that are to support FOMB matters. And I think you said 8.75 of that 27.45 million is for LUMA costs, and the remainder is for PREPA. Was that right? Okay. Okay, so is the line 42 item, is that a PREPA budgeted item, or is that a LUMA budgeted item?
By PREPA budgeted, can you clarify what you mean by PREPA budgeted or LUMA budgeted?
Yeah, in the spreadsheet that was provided, there was a column for LUMA's budgeted items in the optimal and constrained. And then there were a bunch of columns for PREPA submission.
So I think, let me try to explain, and maybe if it's not what your the question, if it's not responsive to your question, then let me know. These costs are treated as system-wide costs, so they are not allocated as part of the typical O&M activities. So in building the system-wide revenue requirement, we seek from PREPA, the FOMB, what their estimated Title III related costs will be. And and then we show the FOMB costs separately. And then the PREPA costs are, we add to their costs, we add our own, what we label interim costs, but it's nothing other than Title III related costs incurred by Luma. They're not, the amount provided by PREPA is a PREPA provided amount. We don't develop it. We only develop our interim costs, but they are treated as system-wide costs, not necessarily against a particular entities, or at least in Luma's case, as against our operating and maintenance budget.
Okay, so for the 51.289 million on line 42, was that amount provided then by PREPA to Luma?
By the FOMB.
By the FOMB, okay. Okay, and the budget shows that these amounts are continuing in 27 and 28. Were the 27 and 28 budgeted amounts on line 42 also provided from the FOMB?
Let me confirm.
Or were those, did you basically just take the 2026 amount and apply an inflation factor, which is, looks like it might be the latter?
Conferred with my team, and all three numbers were provided by the FOMB. So for each year, the number shown in line 42 is a FOMB provided number.
Okay. Okay, and then similarly, the line 41 amount shows additional amounts for Luma's interim costs. And those are shown as well for fiscal year 27 and 28. What was the basis for Luma's assumption that the Title III process would continue into fiscal years 27 and 28?
So at the time of when these numbers were developed, we based that assumption based on the status of the Title III proceeding, what we could learn from the filings that were made by the different parties in the Title III court, the updates from the mediators handling or managing that proceeding and negotiations between PREPA, the government, and its bondholders. And at that point in time, the opinion or the sense based on that information was that the expectation of some sort of litigation was high, and that there will not be a consensual deal reached in the near term. So given that the assumption was that Title III related costs, Luma would have to continue to incur those at least into fiscal year 28, although I'll note that they progressively decrease based on an assumed either litigation schedule or some sort of negotiation period.
Okay, and then are any of the 27 or 28 projected amounts, are any of those going to be avoidable if the trajectory of Title III follows a different time frame?
So these are entirely driven by Title III related requests or matters. So to the extent that the cadence of those requests or the Title III cases resolve in its entirety, then they would be avoidable. Yes. So these are very much reactive to requests that are made to us by either by PREPA or the FOMB to support on Title III related matters.
Okay, the line 41 item was titled on the spreadsheet, PREPA restructuring in Title III. We may have already covered this, but is that a PREPA budgeted item? I think you said it was like a system item.
System-wide, yes.
System-wide, okay. Okay, from the original filing to the update we just got, is the increase in the Title III expense on line is that entirely related to LUMA's estimated costs? The amount of increase that was recently included in the revision?
Sorry, can you repeat the question?
Sure. The amounts changed from the July 3rd filing to the filing that was recently submitted. What is the cause of the amount of increase? Can you just briefly cover that?
Yeah, as it relates to line 41, the increase is in our July 3rd filing, we inadvertently did not include LUMA's interim costs within the PREPA Title III restructuring Title III line item. So we made that adjustment to include that. That's the only adjustment that was made to that line.
Okay, so the entire change then was for LUMA interim costs?
That's correct. And Mr. Smith, I do want to make clear that my responses as they relate to the nature of the Title III related costs and whether they are avoidable or not are entirely limited to LUMA's interim costs. I cannot make any representation related to PREPA's component of those costs.
Okay, understood. I guess I think that kind of covers what we had about trying to clarify the line 41 and 42 items. We did have a clarifying question on the Schedule C2 line 7 other income item.
Mr. Smith, hold on one second. If you don't mind, I'm going to go by category here, and I want to make sure, so I'll come to the other income in a moment. I want to make sure that we get Mr. Brady's question and also let PREPA ask its questions under Title III. So I'll come back to you in a few minutes, okay?
Okay, that's fine.
Yeah, thank you. Can I get Ms. Valle up here for a second again, please? And then I'll come to you, Mr. Brady.
Yes,
That's
sir.
what I'm going to do, colleagues. We're going to go category by category. We're going to see if there's anything that has to be filed after this. We're going to try to learn as much as we can. So let me ask Mr. Figueroa first. And again, I'm just here to gather information. I don't make any judgments about anything. LUMA doesn't have any control over the FOMB costs or influence, right? You just mark them down and put them onto the spreadsheet. Is that about right?
Right.
Does anybody, as between Ms. Valle or Mr. Figueroa, know if there's any arm's length bargaining over the size of the FOMB costs that go into rates? Do you know, Ms. Valle, is there any bargaining between the government of Puerto Rico and the FOMB over what these costs should be? Do you know?
Not that PREPA is aware of.
Okay, you would know.
Yes.
Okay, in other words, if the PREB puts into its final order that the FOMB costs that go into the rates or whatever FOMB asks for, and there's no arm's length bargaining over those costs, your understanding is that would be a correct statement?
Yes.
All right, well, if you don't mind putting it on your list to make sure that we're right, because we certainly don't want to embarrass anybody, not that there's anything to be embarrassed by. But that's what I wanted to make sure, and that the Energy Bureau itself, as I understand the law, and I'm just a hearing examiner, as I understand the law, when the utility has an obligation that it has incurred by statute or reasonably by contract, it's a black letter law that the regulator has to include that cost in rates. There's no regulatory discretion about it either. If it's a legal obligation reasonably entered into or entered into without choice. But I want to make sure that I understand this factual and legal situation so that I don't give the wrong advice to the commissioners. So if anybody understands the situation differently, you're welcome to correct me anytime between now and December 19th. Okay, then, thank you. Let's go under the questions in the agenda for Title III. Let's go to the four PREPA questions. And let's see if there's anything that Ms. Valle or her colleagues want. Oh, I'm sorry. Mr. Brady, why don't you see if you have a follow-up? Go ahead, sir.
Yes, thank you. I had a timing-related question. Mr. Figueroa stated a few times that the FOMB provided those costs to LUMA. And I was wondering whether that occurred before or after the recent terminations of 6 of 7 of the FOMB board members.
Were requested as part of the buildup of the revenue requirement for the fighting.
I'm
So
sorry. I'm sorry, Mr. Brady. I didn't hear the answer well. A little bit again. You don't have the best speaker today, Mr. Figueroa. But please restate.
I apologize. I might be speaking to not loud enough. I was saying to Mr. Brady's question, so very succinctly, yes, they were requested before the recent changes to the oversight board.
The problem isn't your volume. Your volume is more than fine, Mr. Figueroa. Okay, Mr. Brady, you got a follow-up?
And there's been no update or follow-up for those numbers since those recent changes?
No.
Okay, thank you.
Why'd you ask that question, Mr. Brady? What's the significance?
I think that the status of the Title III is now in question as a result of the massive change in the board's membership, as well as the loss of a large block of formerly supporting parties that had supported the previously proposed plan of adjustment. And so that it may well have an effect on the estimate of FOM, advisor, and other Title III costs.
Okay, thank you, Mr. Brady. All right, Ms. Valle, we're going to go back to you now. And if you have these questions under Title III, we're glad to hear them.
Okay, so the first question is, please confirm that the increase in PREPA restructuring and Title III expenses is related to LUMA's Title III expenses. So this line is titled LUMA Interim on the Sheet 1 tab of the Excel file, titled PC of LUMA Fin 2, Attachment 1, row 11.
The adjustment to the interim costs to that line item is reflective of the inclusion of LUMA's interim costs. No other adjustments were made.
Okay. Please confirm in detail the scope of what LUMA considers to be Title III related expenses.
So Title III expenses are what are called interim expenses are defined in the supplemental terms agreement under which LUMA is currently operating the TMD system. And under that agreement, the parties have agreed that LUMA would be able to recover any costs incurred in connection with Title III related matters, and Title III related matters are generally defined as any support that is required from LUMA as operator in Title III or PROMESA related proceedings.
Now, excuse me one moment, Ms. Valle. Now on this one, Mr. Figueroa, or perhaps this is a question for your counsel. would it be correct to say that the Energy Bureau here does have discretion over the reasonableness of costs that LUMA incurs under this obligation? That is, there's no ability of the Energy Bureau to question the obligation, but it does have the authority to review this cost like any other cost. Is that a question for you, or is it a question for council, or does somebody just want to think about it? Mr. Figueroa, you first.
I'd rather get a chance to confer with council and provide a.
Right. Well, are you involved, Mr. Figueroa, at all in determining who incurs these LUMA costs and how much they are? Is that within your domain, or is it within somebody else's domain?
It is partially within the department that I oversee, as well as with my colleague, Mr. Andrew Smith. But generally, they, as I said, these are reactionary costs, are not costs that we plan for. So we may get requests from either PREPA or the FOMB to provide certain information or develop certain information in connection with Title III proceedings, and we then go about providing that and supporting them in any way. So, so as I said, they are the agreement itself recognizes them as such. They are not necessarily O&M activities that we would perform as our normal operator duties. These are just reacting to the fact that PREPA remains in Title III.
I understand that, and would you provide an example or two of the types of costs? Are they legal costs? Are they costs relating to commenting on the adequacy of the system or future operating expenses? What kind of costs are we talking about?
So I would say generally it involves both technical and legal support. For example, we have been requested in the past to participate in depositions related to the Title III proceedings. So those type of costs are part of what we consider Title III costs. We are requested by the FOMB, for example, or may be requested to provide certain information regarding development of capital programs and capital investment plans, and provide that information as well. So it is very much any type of request from the FOMB or PREPA that they require in order for us to support that process.
Okay. So request comes in, you are obligated to honor it. You choose the method by which you honor it. Is that a fair statement?
We are required to honor it. That's part of our duties under the supplemental agreement. And I would say it's provision of those of that support it's a mix of internal and external services depending on the particular request.
So let me ask you this question. So your projected costs that are in the proposed revenue requirement, these are your estimates. These are LUMA's estimates of what the cost will be associated with directives under your obligation that you don't quite know what will be yet, but you have to, sounds like we have to estimate my contracts. Is that basically it? You have to make an estimate of what's going to happen, and that's what goes into rates, or that's what goes into your proposed revenue requirement. Is that right?
So for purposes of the revenue requirement, yes, we estimate what we think based on different factors will be our cost. The supplemental agreement does not establish a cap, so it simply provides that whatever costs are there reimbursed. But we base our estimate this particular case by looking at actual costs that we saw in the previous year, and also a judgment based on the status of the proceedings at that point in time.
Yeah, and that estimating process is within your domain.
It is.
And so what's going to happen if during the fiscal year, the actual cost that you incur to carry out these obligations varies from what you've projected? What I mean to try to understand for a moment is, I know for all your other costs, LUMA's other costs, it's all ratepayer money. It comes from PREPA through various accounts at your request. Is this just another one of those costs like that? Or is it treated some other way, Mr. Figueroa?
I would say it's treated in the same way, in the sense that it becomes an obligation that we have to serve, and so we allocate resources to provide that, to be responsive to that request. Although I would just caveat that in the O&M set, right, in our traditional operation duties, we have, I believe, much more control over those expenditures, because we can manage them depending on what the actual expenditures are and what the needs of the system are throughout the year. In this case, it is very much a request for services that we then provide to PREPA or the FOMB.
Right, and that's really what I'm getting at. What I want to understand is that, let's just take a hypothetical. Let's say, I don't know what you're allocating. I didn't check the spreadsheet before today, but let's say you allocate $10 million to this entire service of the Title III process, and you get to your 10 million amount, say 3/4 of the way through the year, and you see more tasks coming across your desk, and you need more money, and the ratepayers haven't provided it. So what happens then? Do you, as with other situations, do you seek a budget amendment with the Energy Bureau? Do you underspend some other area to make up the difference, or have we not ever gotten there yet? So this is a first-time question, Mr. Figueroa.
I do not have the information, Rick, whether we've in previous years been in that position. What I would say is, under the terms of our agreement with PREPA, it is PREPA's responsibility to reimburse those costs at whatever level they are. So I would say it becomes a PREPA question at that point in time.
Well, let's not make it too simple. Hold on, Mr. Figueroa. It's a PREPA question, but the amount of money that PREPA is receiving is fixed by the Energy Bureau's rate decision, which will come out no later than April 16th, 2026. So I think my question remains, are you saying that PREPA then has the discretion as to, without your influence, as to where to take the money from so that it underpays you for something else? Or is that something that you work out? Or is this something that we haven't thought about before and need to think about now?
I would say that PREPA has a responsibility and an obligation to refund those costs. And therefore, if in your hypothetical, there are insufficient funds allocated within the rates to reimburse actual costs, initially it becomes PREPA's responsibility to solve that problem.
Well, Mr. Figueroa, I know you're doing your best, but I don't think I'm getting an answer to the question that we both think is pretty important, which is who is going to decide which other area gets underspent in order to pay that amount. And so I want to ask you to think about the question, and when you come up with a pretty good answer, let us know, preferably before we get to the evidentiary hearing. Now, I know this isn't the biggest dollar item in the world, and I'm not suggesting you're being evasive. There's no criticism here, but I don't know how we work it out when that situation occurs. And it's precisely because of what you said, that these are not dollars that you can really do anything other than, these are dollars that you can't control through your own operational decisions or your own, or even predict based on your own operational expertise. This isn't what we hired you to do.
Right, and my reaction, Mr. Hempling, would be that precisely because they are not meant to be what our ordinary operation would be, the way that they are reflected and contemplated in our agreement is that they would not go against our operational budget. So that is why it seems evasive, but my reaction is, under my applicable agreements, it would be unreasonable and actually to the detriment of our customers if we would have to reduce expenditures in our O&M budget to cover Title III related costs. That is precisely why these are treated as separate and then fully reimbursable at their actual rate.
Well, you're giving me the information I need now. Thank you, because what you're telling me is that PREPA could be in a fix, and the Energy Bureau needs to know what it should do, if anything. You know, it's like almost like a fuel cost rider situation. If we've put in a certain amount of money for something and there's an obligation to pay it and there isn't enough money, well, we handle that every month or every quarter. Mr. Smith knows this area, and get it trued up. And I think what you're telling me is that maybe despite the small amount of these dollars, we need to think about what the solution is if that need for a true up arises. Do you agree?
I would absolutely agree. I think this same logic applies to many other areas where, for whatever reasons, costs are not either predictable or controllable. I've just simply mentioned outage-related costs.
All right. We know about the outage-related costs. So I want to signal to one of my internal colleagues who's responsible for the FOMB area to make a note of this, because I'm not taking notes while I'm talking, that I don't know if this is the biggest thing for us to worry about, but I can foresee more letters going back and forth between LUMA and PREPA, and I'd rather not have to see that if we can come up with a solution, because all we're dealing with right now is an educated guess about what these costs are going to be, and the costs are obligatory, and they are absolutely outside of LUMA's control. When we're talking about the costs that are not the ones that you incur. Okay, Ms. Chambers, well, let me see if Mr. Brady has a comment or question, then we'll see what Ms. Chambers wanted to share with me. Mr. Brady.
Yes, I do have a question, and I just wanted to preface it by saying these may not be the biggest costs relative to the large overall size of the revenue requirement, but lines 41 and 42 do sum up to over $78 million, so it's not nothing. I wanted to ask the converse of Mr. Hempling's hypothetical, which now, based on recent developments, may well be more likely, which is what happens if the actual spend on these amounts is significantly less than the $78 million estimated? Is that difference then reconciled back to ratepayers, or how is it used?
Well, is that a question to me, or is that a question, Mr. Figueroa? What are you asking, Mr. Figueroa?
Well, per this construct that we've just discussed, they estimate these based on a certain point in time and the assumptions that they make at that point in time. Things have changed since that date. What happens if they overestimated by some significant amount?
All right. Well, do you have any answer for now, Mr. Figueroa? Because I think this may actually be an Energy Bureau policy question. But Mr. Figueroa, any thoughts?
I would just say that it would be the same as if there was a under spend in any other area of the operation, right? Right now, there's no true up or credit mechanism in the rates whereby underspending in a particular area the money gets refunded to customers.
Well,
that's helpful. So I guess the follow-up question I would have to that is, if that were true across many categories or across the revenue requirement as a whole in a large way, what then would happen to that money as a result of the underspend?
I think that's part of that's an Energy Bureau determination. I would say, based on actuals observed over the last couple of years, it's quite an unlikely situation. But at the end of the day, whether there's some sort of crediting mechanism, that would be up to the Energy Bureau to decide. I would argue that there's plenty of other investments that are being postponed, for which if there's an underspending in one area for whatever reasons, the excess revenue can there's definitely somewhere it can be allocated to the benefit of our customers.
Yeah, I think, Mr. Brady, that what's interesting about your question is the part that was unstated, which is whether the Energy Bureau should treat this particular cost item as something different from all the other cost items, which, as Mr. Figueroa says, are going to be part of a big net. Frankly, I hadn't thought about the possibility that if we get to the end of the year and we end up spending less than what was required, as Mr. Figueroa said, that hypothetical, frankly, never emerged in all of my dreams. But I hadn't thought about what the regulatory solution should be. Are you suggesting, by the way, Mr. Brady, that for that cost alone, we should isolate it and make a refund in that hypothetical? Or are you just sort of getting full sense of the possibilities for now?
I'm trying to get a full sense of the possibilities, but I think logically there may be a distinction between the sort of legal costs associated with the Title III category and perhaps project costs elsewhere, such that if this amount is overestimated, as it may well be, given recent developments and the fact that, the board has said in its last status report to the court that it would prefer to stay litigation until a full board is constituted, which we don't know when that will be, that money should not just go into a LUMA slush fund.
Okay, well, you don't have to react to that, Ms. Mercado. I got it. Anyway, I want to thank you, Mr. Brady. I personally had not thought about this, and I'm learning about it right here. And I've made a note to have somebody on our team be thinking about this. I really don't think we need to or want to argue about it right now. I do think you pose an important question, and I've noted it. Ms. Chambers, yes, please proceed.
Yeah. Well, one, I would object to the categories.
I know you would. That's why I said don't worry about it. Just go on your next point.
But your other point I was trying to before it's now moved because I was trying to help by having you restate the question when you didn't think that it was being answered, but it seems like you now received the proper answer, so it's no longer valid.
All right.
Thank you.
All right. Everybody's 1 second. 1 second, please. Remember, we're all learning together. We are in a situation without precedent, and we're all learning. Mr. Figueroa.
Well, and apologies for interrupting. I wanted to maybe make sure that while the discussion is being limited to LUMA's interim costs, that whatever approach is at the end of the day applied to all the different parties that add up to the total Title III restructuring costs.
Yep, thank you. All right, Ms. Valle, I can't remember where we interrupted you, and so I'm going to turn it back over to you. Did you have more questions, Ms. Valle?
Yes, there's an additional question under the Title III part, which is, and this is a focus on requesting documentation. So the question is, please confirm with supporting documentation that LUMA's Title III budgets to date have been used for Title III related work streams.
Well, are you asking for documentary, or are you asking for Mr. Figueroa's comments?
Both, I would say both.
Well, let's see what he has, Mr. Figueroa.
I mean, we apply these costs following the definition of the supplemental terms agreement. So, so that's they're pre-defined there, and we are able to track those costs, either internal labor hours allocated to Title III related activities, or external support provided in relation to that. We track those and then allocate them to that line item. So we can confirm that we do that following the definition of interim costs and expenses under the supplemental agreement.
All right, Ms. Valle, what I want to suggest, if you have more follow-up in terms of documentation, I think I would call that entering into the discovery category. So handle that through the platform. Do it soon, though, because we're getting short on time.
Okay.
Anything else, Ms. Valle?
No, not under the Title III part.
All right, thank you. Let's see if I have anything left on this topic, and I don't. So, Mr. Smith, we're going to go back to you, and we'll move to the category of other income on the agenda. Mr. Smith? You want to show yourself? There you go.
Okay, our next area where we had some clarifying questions was on the other income item. The LUMA explanation indicated that.
I just like for these questions, I will refer to my colleague, Mr. Andrew Smith, LUMA's Chief Financial Officer.
Okay, That's fine. The Luma explanation said that the other income was standardized to the number used in the Energy Bureau's July 31st provisional rate order. And then Luma applied an inflation rate to get to the fiscal year 2027 and 2028 amounts. Why has Luma identified the correction to the fiscal year 2026 amount for other income as an inadvertent error in its July 3rd filing?
Good afternoon, this is Andrew Smith, the Chief Financial Officer of Luma. It was an inadvertent omission on the part of Luma, and so we've just corrected that.
Okay, does Luma believe that the collection of the 84.4 million is going to be achievable in fiscal year 2026?
So historically, we've collected approximately 90% of the other income items. Assuming that historical pattern persists, we would expect to collect the vast majority of those other income items.
And that means that approximately 10% Luma thinks is not going to be collectible?
That's correct, based on historical performance. We do make efforts to collect the full amount, but we're not successfully collecting 100%.
Okay, as far as we could tell, it didn't look like there were any uncollectibles on the other income. Was that a correct understanding on our part?
That is correct. I'll ask my colleague, Mr. Figueroa, to correct me if I'm wrong on that in terms of uncollectibles on the broader revenue scope. But on the specific other income, that is correct.
Okay, and does Luma separately identify the uncollectibles that are related to the other income?
So was your question, are we able to identify that?
Yeah, is Luma able to identify that?
Let me confer with my colleague 1 minute, and I'll come back and answer your question. Sorry about that. I just wanted to confirm that I had the specific answer. The answer is yes. We can track what has been collected in terms of what has been identified as other income.
Okay, and does Luma have any reason to believe that the factor or percentage of uncollectibles on other income is different than the uncollectibles that apply to the general customer billings for electric service?
I believe that they are different. And it's because of what is in the other income line items. So, for example, approximately 55% of the other income is interest earned on interest-bearing accounts that hold cash in them, through the course of operations of Luma collecting from its customers and administering the bank accounts on behalf of PREPA. The other largest component of that is late payment and associated fees and interest for customers. And so, that piece is certainly variable. But the factors that would cause that to vary from the overall collections performance of Luma would be very different. For example, I would propose when thinking about late payments, we're already dealing with a cohort of customers that is delinquent on its bill. Therefore, our ability to potentially collect from those customers is different than our overall operating performance.
Does Luma, I know that Luma applied an uncollectible factor more generally to compute its revenue requirement. Does Luma think that there would be any benefit in having a different, more specifically tailored uncollectible factor for either the other income category as a category itself or with components within the other income category?
For that, I'd like to take that as an item for us to explore and think about and respond to that. If that's okay.
Okay, I guess what triggered that thought was it seemed like certain items within the other income category may have a higher uncollectible factor than the general revenue stream from billing customers for electric service. Is that kind of general understanding? Is that consistent with LUMA's understanding?
Yes, sir, it is. And the reason I'd like to kind of think about it is, to your point, when I think about interest income on interest-bearing accounts, that's really a function of, well, again, one, just how much cash comes through, although that doesn't change that much. Interest rates obviously change, but that should be a fairly stable, predictable number. Whereas on the other hand, as you point out, the payment performance or the collections performance on customers who are already in a late payment category could be very different. But what I don't know off the top of my head is how those two interrelate and potentially offset each other.
Okay, I appreciate that. You think that would benefit from an ROI then?
Yeah, I think that's a good idea, Ralph.
Okay,
Thank you, Mr. Smith. Sorry, Ralph, were you finished?
I was done. Yes, thanks.
Okay. Thank you, Mr. Smith. I think, I hope you'll hang around for at least a few more months. Okay, before I forget, so Ms. Mercado, Ms. Chambers, this business that I was talking about with Mr. Figueroa, this situation where there are costs that LUMA has to incur as an obligation that are different from the normal estimatable operating expenses and capital expenditures, suggesting some possible need for a true-up mechanism, and I'm not saying that's a good idea. I gathered from what he said is that this category that we were talking about isn't the only category. So I may have been missing something pretty big over the last few months, and I would like to ask you to think about and discuss with your colleagues whether it would be helpful to the Energy Bureau for you to make a list of these types of costs, for which I anticipate the only solution will be letters going back and forth between LUMA and PREPA as to paying us the money and PREPA saying we don't have it. Well, maybe that's gone on in the past because rates were confined at the 2017 levels and nobody was doing any other true-ups other than fuel and purchase power. But now we have a process where we're going to try to modernize. And so maybe this is part of the modernization process. Am I being reasonably clear, and does that give you some guidance to think about it, Ms. Mercado?
Yes, you are.
Yeah. I don't want to have us get to next April and still have the type of tension and cash flow worries that we've been having. The job of this rate case is to get those problems solved and to get a consensus about the trade-offs between quality and cost and create some predictability here that is free of controversy and where the controversy is replaced by cooperation. So if you can help by giving us that list, because I think there's more to it than I think just the F1B Title III cost, that would be helpful. Thank you. And, you go back and you come back next week and maybe email and say, here's what you think you need in terms of a deadline for this, just so we have some predictability. Does that work for you?
Yes.
Okay.
Thank you.
All right. Thank you. All right. Let's go to the last category here. 2 miscellaneous questions. Ms. Valle, why don't you join us? And Ms. Vasquez.
The first question is, Genera, please confirm and explain the increase in professional and technical outsourced services for FY 26, 27, and 28.
Well, we actually had a question about that because there's a decrease in the years. So if you could point to what do you mean by an increase?
Give me 1 second. Let me confirm with my consultants.
Yes.
Okay, so each year, Genera added 1 million under that line item.
Can you please tell me the number that's not the amount we have in our exhibit 22.2? So if you can tell me which line item.
Okay, let me
Yeah.
confirm.
So hold on, folks. This is, I'm getting an echo here. I think somebody's got some background noise. Yeah, I want to ask Ms. Vasquez and Ms. Valle to try to work this out offline. This is really sort of a discovery question. I think maybe the 75 of us don't need to be hearing about it. If there's I don't mean to be facetious, if there's a controversy, I'll hear about it. But why don't you work that out, Ms. Vasquez and Ms. Valle offline? And if there's any trouble, let me know. Okay, thank you. Ms. Vasquez, I think maybe your speaker is not ideal, but anyway, Ms. Valle, that's how we're going to handle it. Let me see what Mr. Brady's question is. Are you ready? You want to ask the next question, Mr. Brady? Is that it?
I can, but before we move on, I just wanted to say, to the extent that prior question is worked out, the bondholders had the same question, so I think there might be some disconnect in the papers because we were also seeing the $1 million increase. We didn't submit it separately because PREPA had already asked the same thing.
All right, well, when you all work that out, why don't you transmit the, I tell you what would be best, work it out, record the working out in on the Discovery platform, but also email it to everybody so that Mr. Brady doesn't have to run off to the platform every day. Is that okay with you, Ms. Valle, Ms. Vasquez?
Yes.
Yes.
All right, excellent. Okay. And Ms. Vasquez, you take a look at that get somebody half my age and have them look at that speaker and see what you can do with that. Okay. Is there anything else? No, don't even ask that. Let's let me take a suggestion that we take a 5-minute break. Thank you. I think that was reasonably efficient.
Sorry, we have one quick question at the end of that list.
I'm so sorry. Of course you do. Yes, go ahead.
Hopefully it's a very quick one. We were just wondering, now that we have the revised revenue requirement work papers, if we should also expect revised rate design work papers.
I will pass that on to Mr. Sam Shannon.
Hello, everyone.
Mr. Shannon, what do you have for us? I'm not sure I'm going to require this, so let's just see what you're going to answer, and then we'll see what we're going to do. Go ahead.
Sure. So, and apologies, we had discussed this at I believe a prior technical conference and in some conversation with the Bureau's consultants, Mr. Brady. The plan was not to file updated rate, design, and cost of service schedules with all the different changes to revenue requirement until much later in the process. We hadn't exactly worked out when that will be, but it'll likely be sometime maybe like after the revenue requirement hearing or sometime later on down the road there. So it's just a single update to those to capture as much of the changes to the revenue requirements as we possibly can.
Okay. Now that you say that, I'm remembering, and this is because some of it is done manually, right? So it's a process to update.
It's more just how, like, trying to avoid a bunch of, duplicative, massive spreadsheets being done over and over and over again.
Okay, so I think we would just request that we at least get an updated version before the rate design hearing.
Well, let's, that will actually be my decision. Let me think it out with you aloud for now, Mr. Brady, and we can come back to it later. Basically, this was not a huge change in the revenue requirement that we just learned about. So I want to ask Mr. Brady first, what's your gain from finding out that each of the rates that they proposed, which aren't going to be the final rates anyway, unless there's some miracle that the 5 commissioners all happen to coalesce around a proposal that was made in July after a hearing that's going to go for 5 weeks. What's the value to you of having that new version? Or were you just being meticulous, which I appreciate?
I would need to confer with our experts on that because the value would be more to them than to me, to be honest. But
Okay.
I think that by the time the rate design hearing comes around, there may have been more changes beyond what would now be reflected.
Right. Well, here's my thinking, and it's very informal, it's very tentative, and it's completely uninfluential. What ultimately matters is the revenue requirement that the 5 commissioners decide, which will have some resemblance to what's being proposed by everybody, because it'll be our obligation to the Court of Appeals to explain how we depart from or accept everybody's various proposals. So I'm kind of missing, frankly, the value of having one more version of one party's proposed revenue requirement when there'll be many parties with many views about revenue requirements. That's what that's the thinking I've had before you brought this up. And I'm sharing it so that you can react to it and tell me what you think. You can either do that now or some other time. But that's what I want to ask you to do, is talk to your experts about what's the value of this, because it's going to be up to me whether I'm going to require another, unless somebody files a pleading and the commissioners tell me what to do. And I'm at the moment questioning the value of any more filings right now. And I give you my explanation. So back to you, Mr. Brady.
Okay, I will do that and come back to you if necessary.
Yeah. All right, thank you. And if anybody else has any thoughts about that, that's why I shared mine today. Okay, anything else, Mr. Brady?
Nothing
All right.
for now.
Thank you. Everybody's been very helpful today. Why don't we take, I've got 243. What you can see on the agenda, we have some more work to do, although I think it will go sooner. Go faster. I've got 243. Let's come back at 2:50 my time, and we'll go to part 2 of the agenda. I'm going to go dark, and so should everybody else, and mute, and we'll be back in a few minutes. Can I ask my team to meet me in my Zoom room, please, briefly? Thank you. Now, can you hear me? Oh, that's even weirder. Okay, speak to me, Raphael. No, I can't hear you. What the fuck is going on? Yeah, I can hear you. Okay, Gerardo, you can take down the welcome screen now, please. Okay, colleagues, welcome back. Let's start work on item 2 in the agenda. So I think this is more of a conversation for council. If I can get the at least the main council up here showing their videos, that would be great. That would include, of course, ICPO and the 3 utilities. Ms. Vasquez, by the way, can you hear me okay?
Yes, I can.
Yeah. Well, first of all, welcome to our proceeding. I haven't made your acquaintance before, and would you do me the favor of emailing me the list of council that are Herneta council so that I can keep track of everybody?
I will.
Okay, and are you now the main person that we will be dealing with? Well,
yes, I will be.
I hope the right word is congratulations, not condolences. We're glad to have you, and we'll try to make it fun for you. All right. All right. Let's see. Do we have Mr. Vasquez for ICPO today? Ms. Chambers is here. All right.
Yes, we're here.
Are. Nice to see you again. Let's see. Who else do we need here? Ms. Valle. Let's make sure you're present too.
I'm here.
Okay, there you are. All right. Well, this is a time for you all to comment. We'll go through each of the issues. I'm not looking for a long discussion or a debate. My question is, do you see benefits or detriments to my, first of all, bringing these issues explicitly into our rate case? That's number one. Are they relevant to the rate case? And number two, do you have any ideas for how we create a record on these matters? And I think if I recall my order, I gave you a couple of options. I do think it would be valuable to have a panel on each, which would mean people there to talk to the commissioners and me and my colleagues about these questions. The question is, do we try to have submissions in writing ahead of time? Do we just let you come in and talk about it? Obviously, you will have prepared, and then do your writing after the hearing, because we have a pretty congested schedule now. Or is there some other way? So that's my hope. I just want to listen right now to what you have to say. So why don't we go one issue at a time, down Appendix B, starting with the practicability question. And let me go in a different order each time. Let me start with Mr. Vasquez. And do you have any thoughts on this one, whether you think it valuable and how you think we ought to go about it?
Morning, good afternoon, everybody. We do see that it is important to consider and discuss the practicability of the rate increase. I believe ultimately that will be relevant actually for the establishment of the new rates. We have seen what it is, the revenue requirement that has been filed, and we do have at some point to discuss this. For our part, we don't have any objection to be discussed with the panels and be submitted via our briefs, our position about it.
So do you think this is, thank you, do you think this is something that would be worth having written submissions ahead of time, or do you find that just not really realistic given the schedule that we have? Have you thought about that yet?
Yeah, we thought not ahead of time, but something to comment for at the time of after the hearings and the briefs.
Well, you know, I want to make sure that the panel is a useful panel, And it becomes more disciplined when people have done thinking ahead of time. So I want to make sure that we do something to ensure the quality of the conversation, Mr. Vasquez, right?
Right.
Okay. Well, let me hear from Ms. Chambers. Now, we don't have to repeat each other. If there's nothing new to say, tell me. If not, we'll just keep moving. Ms. Chambers, any thoughts?
Well, we actually did do a little preparation on this, and so I'd like to allow Mr. Figueroa to address this, and then I
Okay.
can support him to the extent he
All right.
needs my support.
Okay, Mr. Figueroa, what are your thoughts?
Thank you, Mr. Humphrey. So on this matter, I think our position is that we recognize that it is a challenge and that the revenues might not necessarily materialize as expected, and that then creates pressure on the utility as to which expenditures are it's able to commit to and which expenditures might have to be deferred. That's certainly the situation now, but I would say that that's not necessarily a unique circumstance to Puerto Rico. It's something that other utilities also face. Maybe in Puerto Rico it's a little bit augmented given the conditions of the system today. But in that sense, I would say, while we agree it's an issue that should be explored, addressing issues like net metering customers or the push towards net metering customers, affordability and other items, in the framing that you presented in the request here, is probably better. Policy decisions that are better studied in a different proceeding. I would say that the current rate case is constrained to the 180-day term plus the extension if the Energy Bureau deems it appropriate, and to the extent that there's a need to, in the near term, address a reduction in revenues generated by the rates. Well, that can be solved through a revenue decoupling mechanism, such as the one that's being considered and developed or proposed as part of this process, while the broader policy decisions are, assessed in a separate proceeding. So I would say we'd prefer this be addressed more thoroughly, separate from the current rate case.
Well, Mr. Figueroa, let me, if I may, informally push back on that. Full agreement with me, and I'm sure with the 5 commissioners, that we're not going to turn the rate case into a policy case about solar. Exactly, that belongs in a separate case. But we sure know that for purposes of determining the billing determinants and the load forecasting that influences the billing determinants, we have to take people's reactions to the new rates into account. So it comes up there. But it seems to me that the issue of whether people are going to pay doesn't go away because you have decoupling, because decoupling does is react to the insufficiency of the revenues by raising the rates more, which could lead to more insufficiency of the revenues. So the decoupling doesn't solve the problem. I think what I'm taking from what you said is that it's going to be necessary to have a pretty precise description of what this subject is so that there's no mix-up. We're not making solar policy, and we are doing something beyond what we're doing when we do the load forecasting. So that's what I'm going to take away from what you said. I will come to you, Mr. Gonzalez, in a moment. As you know, I put your entire comment into a footnote. I think I did. Yes, I did. It's staring right at me right there. Okay, Ms. Valle, did you have anything to add to this that's not repetitive?
PREPA is inclined to that the practicability of the rate case of a rate increase be addressed in the rate case. I will. My consultants would like to state our position on how this would look like later on, but we do wanted to state for the record that this matter should be addressed as part of the rate case, and that there are important implications, for instance, relating to Title III.
Well, now I just lost you there. unless what you meant to say was that unless what you meant to say with your reference to Title III is that if and when debt becomes a legal obligation of PREPA and that ends up being part of the rates, which involves two separate decisions, then that fact makes even more necessary than now the need to understand what happens to the question whether people actually pay. Is that why you referred to Title III?
Yes, and certainly the practicability of the rate increase, it's at the heart of Title III, and it's important. So I believe that the energy bureaus should be briefed on that particular.
Yeah. So did you have an immediate response, Mr. Figueroa? Is that why you just put your hand up? Okay, we'll come back to you after you figure this out, Mr. Figueroa. Turn your darn thing off there, will you? Thank you. Ms. Vasquez, anything to add?
We don't have anything additional to add, but if this is going to be discussed, we definitely think it would be appropriate to have written supplemental submissions and not just like discuss it in the live hearing. I think it would benefit everybody involved to have written supplemental submissions.
Yeah, I will tell you what I'm concerned about is that it's just possible that data will matter in terms of the bureaus making decisions that approve rates that are less than what some people ask for. And if the reason that the Energy Bureau has is ability or willingness to pay, and the Bureau is not making that judgment based on data that was in the record, then we're not doing the job required by administrative law. And that's, I assume that's what you're getting at, Ms. Vasquez, and that's what I've been thinking about, that I don't know that this is an issue that lends itself just to generic conversation, but it may require data. Is that what you're talking about, ma'am?
Yes, I agree.
Yeah. Well, let me go back to Mr. Figueroa. Go ahead, sir.
And thank you, Mr. Hempling. I would say what you stated is precisely why we believe that it should be part of a separate proceeding, because the conversation itself requires probably a lot of data gathering, interpretation, so that you have enough information to make and the type of decision that as you're describing it, that the Energy Bureau will want to make. However, and this is not trying to avoid the issue that you're raising. It's simply that I think we are better off taking steps. We will go through a revenue requirement determination that will be supported by new rate design. I think it will be beneficial to understand how those rates are being accepted, if you will, by our customers, and how their behavior is being influenced by that. And that should inform then other policy decisions that the Bureau might want to make to enhance either the customer's ability to pay or the effectiveness of the rates that are being established. And to the extent that there's a concern that in the near term, the rates, there might be a disconnect between what the rates are intended to generate and the revenue that is actually being generated, that's where I submit that the decoupling provides a mechanism to sort of bridge that while the broader policy decision is studied.
Well, thank you. I'm glad we're having this discussion, Mr. Figueroa, because it's a tentative disagreement. I say tentative because I don't take positions that I want to bring out here so that we can make a good decision. Here's what I think you're not addressing, Mr. Figueroa. Let me hypothesize, and don't be running to your cell phones. Hypothesize that the Energy Bureau makes a final decision by April 16th that is a revenue requirement that is, we'll say, 85% of your constrained budget. I just pulled that number out of thin air, 85%. And while the Bureau will, of course, have gone through every number and made judgments about appropriate cost, it then may end up saying, and this is not based on any conversation I've had with anybody, I'm just hypothesizing because I have to. The Energy Bureau says, we would have loved to include items A, B, C, D, and E, but we took them out ultimately because the total is just too high for people to pay. Now, if that goes in an Energy Bureau order without a data basis for it, I don't see your two lawyers about to tell me they're promising not to go to the Court of Appeals on this. And what I'm saying to you is that your comments don't address this problem. And I just want to ask you to think about it some more. As to the revenue decoupling, I made my point that the revenue decoupling is potentially a, what do you call it? Death, I hate that word, death spiral. It's a cliche, but the problem continues to build on itself. Okay, so we're not going to resolve this today, but you're a thoughtful person. I want you to keep thinking about it. Okay, now let's see, where are all the hands going up? Mr. Gonzalez, you know what I'm going to say, that we're not making this case a solar policy case, and but I do want to hear what you have to say if it is additional to what I quoted at page 6. Mr. Gonzalez, always a delight to have you.
Good afternoon, and thank you for letting me participate. I disagree with Mr. Figueroa strongly. I believe that he's completely against solar energy and net metering. And this new rate design, whereby they want to do a higher fixed cost, is just an attempt to derail renewable energy, solar, let's say residential solar customers from participating in the market. And
okay, hold on, Mr. Gonzalez, I'm sorry to interrupt you, but I'm going to tell you right now, you're off topic, okay? The only topic I'm addressing right now is the pros and cons of having a panel on the topic of practicability. That's my question. So what are your comments?
Well, the comments that were made by Mr. Figueroa and is that the broader policy issue should not be discussed, but they are already integrating a broader policy issue, which is to penalize net metering by putting a higher fixed rate. So that needs to be discussed.
All right. You made your point. 1 second, please. I'll do the talking here for a minute. I know about the fixed charge, and we will address the fixed charge when the time comes up in the rate design phase of the case as to its appropriateness. Okay. The question for me right now is whether to have this panel. Ms. Mercado, do you need to say anything? If you do, go ahead. If you don't, don't.
Yes, please, for the record, to strike the comments and arguments by Mr. Gonzalez.
All right. I'm not making any decisions based on his comments, and thank you for yours. And now we'll go to Mr. Brady. So you can hang up your phone there, or whatever, your hand or whatever it is, Ms. Mercado. Mr. Brady, be helpful, please.
Yeah, so there might be a way to sort of thread the needle between what you said is the tentative disagreement between your position and Mr. Figueroa's, and this relates back to Ms. Tierney's testimony, which we submitted on Tuesday, and people may not have had the chance to review that yet, and I won't belabor it since it's a lengthy document, but essentially she testifies that the approach that the Bureau has taken to affordability in the revenue requirement phase thus far is appropriate, that the Bureau has considered affordability through the constrained budget and the optimal budget, and that really, to the extent this enters into the rate case, it's at the rate design phase through things like subsidies for certain customer classes, the allocation of costs to different customer classes in a way that is sensitive to, for example, their ability to pay, and ultimately that it's not an issue that should be explicitly considered at the revenue requirement phase in terms of capping or reducing the revenue requirement, which I think is what some people have proposed, most notably ICSI.
Well, okay, I haven't read her testimony. By the way, it's Dr. Tierney. You might want to know that I've actually known Dr. Tierney since the late 80s, almost 40 years now. You'd give her my regards. And all right, so we've heard from you. Ms. Chambers, non-repetitive, please.
Yeah, I mean, I think what Mr. Corey is saying, we do have a constrained budget proposed, and I know you're talking about potentially going under that in the hypothetical. But I'm trying to understand what kind of data you would be looking for, because I don't think it's data that the utilities would have. So I'm concerned about, how we would even participate. And that's why I think Mr. Figueroa's response makes a lot of sense, because it might be something that would be better handled in a separate proceeding with the rate. It doesn't sound to me like a rate case issue. Normally in a rate case issue that we do, I do lots of rate cases. We don't really consider affordability in that sense. We consider the costs that are needed to run the utility. And then the commission can make its determinations, but, that's not traditionally the area for a rate case. So maybe Puerto Rico has different considerations, but I think that it's going to be hard to do that and get the revenue requirement and the rate design done all in 180 days. And I think that it's just not practical.
Yeah. Well, I wish that was all that we had to do, was take what you said and then drop the point. But right now I'm not agreeing. And I'll tell you that the very specific data is the very obvious data. It's elasticity of demand. And as I told Mr. Figueroa, revenue decoupling does not help you if the elasticity of demand is such that we don't earn the revenues. So the job of the revenue requirement, the job of the rate case, is to produce the dollars that the company needs to run itself. And if we have a situation where the rates are so high that the dollars don't emerge, we've got a problem. Now, that may be a disagreement, and I'm just a hearing examiner, but I do decide what goes into the case unless the commissioners say otherwise. So this was a very useful discussion. I appreciate especially, those who had thoughts that are different from mine on this. And I think especially important was Ms. Chambers' challenge that if the need here is data to ensure that the ultimate decision is legally sound under administrative law, then I should be specific about the data. I think that's a very important point that Ms. Chambers made, and that's what I have. So just so we don't take up the whole afternoon, I've got a train to catch in a couple of hours. I don't want to suggest we're going to be here for a couple of hours. Is there anybody else who wants to comment on this first item?
Mr. Hemsley, I just want to request that if you will allow Mr. Gonzalez to participate, that you ask that he does so with respect and decorum. Baseless accusations of partiality against myself are neither warranted or productive to the discussion.
I think he knows that, and I think he's suitably informed by what you said, and I don't think anybody should take it personally. But I do understand, and I do want to have the maximum decorum so we can have the minimum of time wasted. But Mr. Gonzalez is somebody that I admitted into the case because I find his value contributes, and so that's why he's here. And I hope he did hear what you had to say, Mr. Figueroa, and that he honors it. He will always be listened to by me and by the 5 commissioners and by our consultants. Okay, second topic. Let me not get lost here. So I'm sure you're looking forward to this one, Mr. Figueroa, so we'll start with you. I don't need to repeat what's here. I just need to, I laid it out there, and I want to know first what your thoughts are, and so I'll turn it over to you.
Maybe I start, Margarita Mercado, and if Alejandro wants to add, I will start maybe procedurally. We think that this is an issue that could be briefed, not necessarily supplemental testimony. We have had discussions along these lines with yourself in different proceedings that per the T&D OMA and LUMA as operator of the T&D system, there's no interest in raising rates to raise any profit to LUMA. LUMA's payments are based on a management fee composed of a fixed fee and an incentive fee payment. The amounts and the formulas are set in the contract, so that is why LUMA's position is that it doesn't have the type of conflict of interest that you are flagging in the premise of your question, but definitely could be something that could be added to briefing at the end of the hearings.
Thank you, Ms. Mercado. I hope it's obvious that if I thought that the structure of the OMA was the end of the story, I would not have even bothered to put this issue on the list. So I hear what you have to say, but that's my signal that it's not persuasive. I do think, well, let me hear from the other people. This is what I'm here to do today. Ms. Valle? And again, this is not the time to argue the point. This is the time, excuse me, to inform as to your thoughts as to the appropriateness to the case and methods of dealing with it. Ms. Valle.
Yes, PREPA believes the conflict of interest is also a subject that should be addressed as part of the rate case. Among the areas that we have identified that there may be a conflict of interest, which the PREP should look into, are, for instance, the seconded employees, the use of seconded employees by LUMA, procurement processes, and of course to make sure that ultimately to guarantee or make sure that the budget submitted by LUMA, it's truly a bottoms up budget.
Okay, so we have that opinion. Ms. Vasquez for Genera, any thoughts on this?
Yes, we agree with Luma's position. We think that how the OMAs are structured include clauses that attend to the conflict of interest. The expenses are pass-through expenses. We have fixed fees, but this would be definitely something we could brief the PREB on.
Ms. Vasquez, if you don't mind my putting you on the spot,
Yes.
do you think, and in the past, well, this was in the other case, I mean, we all have our conflicts. I have my billable hours, I make money by the hour, and et cetera. Do you think that Genera has conflicts of interests that the structure of the OMA itself does not resolve?
I do not think so. For procurement purposes, we have the 3 PPO. And again, other than the fixed fee, there's no gain from the cost and the expenses Genera has.
You don't have any affiliates that you do business with?
But any affiliate, any conflict that could be flagged is done through the 3 PPO. So again, the OMA has clauses that deal with any type of conflicts.
Okay, that's useful to know. Mr. Vasquez, I don't want to lose you because you're not on video, so it's easy for me to forget that you're here. And being the representative of the consumers that are going to pay for all this, you're the last person I want to forget. I don't want to forget anybody. Do you have anything to add to this conversation, sir?
Not that much, Mr. Hempling. Actually, anything that could affect and ultimately at the point that we are, that the revenue needed for the system is at that high. Anything that could possibly affect, and we don't have a true bottoms up or actually could affect the decision of what is needed, it is appropriate to consider it in the rate case.
Okay.
So we do think that this is something to be addressed.
All right, thank you. Ms. Chambers, do you have something non-repetitive? I saw your hand go up.
Yeah, I was just trying to understand how this is going to work, because I don't want to be live answering unsupported allegations. So I just would, is this going to be briefed ahead of time? Or how would you do this? Because this seems like it could be the Wild West. There have some kind of control over the process, or would know what we're responding to. Normally, it's done through testimony. So we have a testimony due date. I assume we would have a chance to rebut that before we'd have to deal with it live.
All right, Ms. Chambers, thank you for that. I'm giving that some thought. That's what I'm trying to figure out right now, is how to do this the right way. get evidence into the record consistent with the schedule, consistent with everybody's administrative law rights, and ensure that the Bureau makes a decision that is appeal proof, notwithstanding the fact that somebody will probably appeal it anyway. So I should say overturn proof, not appeal proof. All right, thank you, Ms. Chambers. Yeah, what I take from this conversation is that if this topic is going to be successful in terms of bringing out facts that are necessary, it probably needs to be addressed through some very specific instructions as to what to write, what questions to address, and to put them in writing ahead of time. And that is a challenge because of our timeline. So I'm taking all this back. Maybe not everything can be done in one rate case. Maybe some things have to be dealt with some other year. And that's why we're having this conversation. Okay, because no one's going to make you do anything that is inhuman. All right, the next topic I think is pretty straight. I'm sorry, anybody else on this topic of conflicts? All right, the next topic I think is straightforward. What I envision here, I don't know much about this. This is much more a Ralph Smith issue and other people more technically oriented. But the reconciliation is a standard process at the end of the rate case, and there's some discretion about how it works. And I want to make sure that whatever useful thoughts people have about it are given to us at some point. And this one I do think probably could be handled maybe with some advanced questions and then purely just by a panel, because I think everybody, there's no conflicts here among parties. The reconciliation has to occur. Does anybody have any thoughts on this question? As to the value of having, I think it would be a short panel, probably of the CPA types. And we would probably guide each of these panels ahead of time with a series of questions. Any thoughts on this one? Okay, I'm not hearing any, I'm not seeing any hands go up. All right. The next topic on record keeping. All right. Well, I think you know what this one is about. I'm sorry, Ms. Chambers?
Yes, I think that your point about the questions would be helpful ahead of time on the last topic. I don't know that it really warrants a panel. I think that, we would appreciate knowing what your questions are so we can address them.
Yeah, because we have to have a record on these things, and the commissioners benefit from advice. Okay, next question, next topic. Yeah, here we are 8 years after the 2017 decision, and we still don't have a US of A, Uniform System of Accounts consistency, and we don't have, at least in my tentative, informal, non-binding view, very good matching of costs requested with specific projects. And so the question is how we get there. We originally had talked about the schedule A1 and A2, and you all, Luma, had quoted a $500,000 as a way to prepare for that. And my current thinking is we need to do more thinking about what we're asking for before we have you spend that money. And that thinking has not been done because, frankly, the workload that everybody has, including my team. So I'm flagging this as possibly something that doesn't get decided in this case, but we use the fact that people are in town, some of the CPA experts, to get a better feel for what it is that we're trying to ask for and how soon we can get there. Ms. Chambers? You're muted, ma'am.
Apologies. We've talked about this as well, and as you might have read in Mr. Smith's testimony, he talks about the problem of going to the Uniform System of Accounts until after the remediation has been completed. So I think if we were going to deal with this issue, which, he did address and recommend in the testimony that be the process, we would need to know the timing, and we don't have information about that from PREPA on the remediation process, when that'll be complete.
Okay,
So
I got it.
that's, okay.
I think that probably is the way to handle it. It's, yes, the issue is raised in part by him, although I'm talking about more than just the uniform system of accounts. So I think that this one can be handled as part of the paneling on issues I've still got thinking to do with you about how we set up those panels. But thank you, Ms. Chambers. Any other comments on this topic? All right. I can tell you that without violating any attorney-client privilege, that there's a lot of concern among my fellow consultants about the question whether the level of cooperation among all three companies is sufficient to ensure that there's no adverse effect on cost or quality. And so I've been thinking about a panel of the CEOs to find out what we can do, what the Energy Bureau can do, and what they can do to ease the tension and to assure the five commissioners that there's no adverse effect, because it's not clear. It's an evidentiary question, and it's also maybe this is time to use the Energy Bureau's authority and trust and stature to improve relationships. So that's what that's about. And let me see if there's any comment on it for now. Okay. The FEMA funds, I think, is self-explanatory. There will be a FEMA panel, a FEMA funds panel. We'll see. What will happen is that I expect there will be a PREB consultant providing an expert report on that topic. And so there will be rebuttals, not necessarily rebuttals, or responses to that. And I'm just letting you know that there will be at some point a panel on that topic by itself. Any comments on that? The point being, and I want to make sure people think about this because they haven't yet, whether there's what is the role, should there be a role in the base rates to cover not just the 10% share, but the uncertainty and the timing. That's what this is really about, so that there aren't adverse cash flow effects arising from the need to start projects before the money arrives. That's the question. And there's no testimony on that topic, but I expect there will be commentary on it from one of the consultants, and I want to make sure people are thinking about that. Should there be a base rate solution to the uncertainty about whether there will be FEMA funds for a project? And even if there is certainty about it, then the cash flow problem of the project perhaps needing to start before the money arrives. Because right now, my limited understanding of this topic is that all that's in the revenue requirement that's been proposed is a slot for the 10% sharing, but nothing's in there to handle the possibility that we might want to fund something that doesn't get funded by FEMA, but is still necessary. And then the timing question. So that's what that's about. The last topic for now, before we move on to the next major topic, is my thought that the question of the metrics could be dealt completely outside of the rate case. That, as we've talked before, and this is what I want council to comment on, please. As we talked before, there's a legal right in Genera and Luma to have rates sufficient to get them their incentive fee. Well, the rates are going to be what they are. And if they're not enough, then there's going to have to be an adjustment to the metrics. And we could do that adjustment in this case under the statute, but my thought is we have enough to do. So as long as there is a commitment by the Bureau to do the metric adjustments soon after the rate case, that takes the issue off the table. And I wonder how people think about that, because if I can get people's agreement on it, I can take that to the commissioners and it comes off the case. and nobody has to worry about it. So are there any thoughts today? You're not going to bind yourselves, but are there any thoughts today on this topic? Ms. Mercado, you first, please.
Yeah, Luma agrees with your proposition that this should be an independent proceeding following the establishment of the revenue requirement. Several of the Luma witnesses in their pre-filed testimonies addressed this, flagging or identifying the metrics that would be affected, and stating that the full impact and proposed adjustments required, knowing the revenue requirement, to then propose alternate targets or baselines to meet the requirements of the contract, that the budgets need to be sufficient to allow Luma a reasonable opportunity to meet performance. Thank you.
Right, yeah, the reality is, internally, we're not going to know the commissioner's decision or revenue requirement until sometime probably in early February. And so at that point, it's not like we're going to call everybody back and say, let's talk about metrics. So right now, that's my thinking. Well, I'll tell you what. If anybody objects to that approach, let me put you on the spot. If anybody objects to that approach, I would appreciate your making a filing on that by, let's say, today's the 4th, today's Thursday, by a week from now. You don't have to say anything, all right? But that's my proposal to you, and that is what I would like to take back to the commissioners. So unless I get an objection formally filed, you don't have to write 5 pages in the history and everything else. Unless I get an objection, that's what I'm going to recommend to the commissioners, that this issue comes off the case, and the final order will make a commitment to handle it imminently in a separate case. Okay, next Thursday. Everybody good with that? All right, thank you. Okay. Let's see where we are. Whoa, we've been gone 2 hours here. Do you all want another break or you want to keep going? Ms. Vasquez, what do you think?
We should keep going.
Okay, then we're going to keep going. Okay, you've got the right level of stamina for this crowd. Thank you, Ms. Vasquez. Okay. Okay, so organization of the evidentiary hearing. Today is not a decision-making day. It's strictly to get your reactions to things. So let's start with the tentative panels. That's back on Appendix C. This is not a decision yet. When I would make this decision would be sometime, well, certainly by the end of September. How I calendar it, I'm not sure yet. But the actual panels, I'll make a decision once I see all the expert reports that have been filed. Any thoughts, any comments on this approach? Okay, and the plan is, yes, just so people know, the plan is when this all gets settled out, there will be dates. Why will there be dates? There will be a sequence. There'll be a list of people on each panel. And as to the dates, we're going to have to try to figure that out together, because there's not going to be any way to make everybody happy on this. Okay. If you think of something after today that you want to add, subtract, or comment on, or get angry about, let me know pretty soon, but make it a formal filing. I want to keep the emails to mere logistics. Sequence for each panel, back to page 2. We'll start with questions from the PREB. It can be from me, it can be from one of our consultants, it can be from the commissioners, followed by cross. And yeah, you'll cross people, be sitting up on the panel, but you'll cross your adversary. I've never heard of cross without redirect. I've rarely seen recross useful, but I'm not going to say no ahead of time. We'll see. And I just want to ask people to remember, your main job is to help the commissioners make the best decision. I know you've got your own interests and nobody's taking that away from you, but always try to err on the side of getting us informed so that the commissioners can make the best decision. Any comments so far on the panels or the sequence of questioning? Oh, I know what I forgot to add. And I may also ask panelists if they have questions of each other. Sometimes I've seen really useful insights occur that way.
The total revenue requirement panel, would that be more like financial type witnesses, or what did you have in mind for that?
Yeah, That's a very good question, Mr. Brady. It's actually one of the panels I'm least sure about. So let me just gather my thoughts for a second. I mean, you've got a point here. My problem is right now I'm trying to think back to the panel in 2016 where Mr. Smith and his internal colleague, Mr. Dady, and the main revenue requirement witness was there. And I apologize, Mr. Brady. I have to get back to you on this. And let me put a big question mark, because I think that's what you're asking. Why on earth is this thing here? What would it produce? Is that about it, Mr. Brady?
It is, and some of the proponents have organized their witnesses across a number of different categories that then build up to the revenue requirement.
Yeah.
So I was just trying to think who would actually be the witnesses there.
Yeah, I think that's a very solid point, and thank you for that. So let me rethink that one. It kind of gets to the issue that was raised with Mr. Figueroa before, sorry, with Mr. Shannon, in which I said, is there really any value, or what is the value of, quote, updating, close quote, the proposed revenue requirement of one entity when we know it's all going to change sometime between then and April 16th. So thanks, Mr. Brady. I'll give that more thought. All right. If you have any thoughts, anybody, let us know. All right. Let's keep going here. Okay, so now we have Luma's long list of logistical questions. So let me tell you what I know and what I don't know so far. I think that's the reason why you asked. Thank you for creating this list for us. I will say that most of them were on our list, but some of them weren't. So let me tell you what we know so far, colleagues, and you can react as you wish. Okay, first, I'm on Appendix D. First question: remote testimonies. Well, we've had a conversation about this before. I can tell you right now that the chances that there's going to be any remote testimony are remote. Okay, right now I'm figuring family emergency, illness, or the airplanes aren't flying. I don't think we're doing convenience, and I don't think we're doing, my cat had a hangnail. And of course, I've got a hearing I've got to testify at tomorrow, so I guess I'm going to have sympathy for somebody who has to be in a hearing to testify, but that's the kind of thing we'll try to work out ahead of time. Now, I'm not making a promise about this. I'm just telling you that my view, and I've gotten this from the commissioners as well, is they want to see people in person. And yes, I know it's a pain to travel all the way over there and then find out that the questions lasted 10 minutes. I've been there. And we'll try to avoid that by making sure that nobody if somebody really doesn't want to have any questions for somebody and I don't have any questions and the commissioners don't, we'll obviously not make them travel. So we'll be sensitive to that. The confidentiality issues, which are really separate, I'm aware of the issue. One of my colleagues, Mr. Rafael Sosa, is in charge of that, and we will be working out procedures. I've dealt with that as a FERC judge, and we will make sure things happen. I do want to tell you my hope is that we don't have to do this, that we don't have to worry about it because nobody's going to rely on it. I can tell you, this goes to the next question, that when I was a FERC judge, you have these two options. One is to deal with the confidential information in context, which means you're going back and forth between secrecy and non-secrecy, versus having all the confidential stuff dealt with in one separate hour, at some point during the day. Each has its pros and cons. The problem with the former is it's somewhat disruptive, although I had such a great paralegal at FERC, it was pretty smooth. The problem with the latter is your transcript loses its momentum. It loses its logic. You've got issues being interrupted by other issues. I don't much like the latter. I like the former, but my hope is we have to do this extremely rarely. Yes, there will be an electronic platform. So Kate Bailey, our former New Hampshire commissioner who is in charge of that, is working on that matter. And there will be a point at which she has it all in place, and there will be an educational session or two on it. And we're creating a schedule for that internally, and we'll be ready for it well before the hearing. But the likelihood is that, like I had at FERC, you will be putting your you will be putting your, everything will be electronic. There will be no paper. Okay, you want to bring paper, it's your paper, not my paper. And you will be putting things through the web, you will be putting things onto the platform. The question I want to raise with you here to think about, most exhibits will be exhibits attached to the testimony ahead of time. So they'll be there and you'll just be getting them marked and I'll deal with the admissions, etc. The question is what to do about exhibits that you want to introduce during your cross-examination. And the question is whether the Bureau, I would require you to put them up there ahead of time versus you're doing it right there in the middle of the hearing. So I want to ask you to think about that and let me know. Pros and cons. If you're counsel, I guess you want to surprise the witness. That's a pro and a con. It's a con for the witness. It's a pro for the lawyer. The problem with doing it during the hearing is we lose time. And I don't want to bring people back the last week of December. So I really would like counsel to think about how big is this surprise business. I have yet to see a regulatory case whose outcome really turned on whether somebody was surprised. I'm deadly serious. So if you can kind of put your, I wish I were a criminal lawyer kind of hat off and just ask yourself, how serious is this? And if you all can tell me by next Thursday that you don't care or you do care, put that in your next Thursday filing and try to humor me on this, okay? Because I think you'll all want to be done with this in the fewest number of weeks. No, this isn't FERC where I had it when I was a judge, and the people who had a lot of money had this, thing where they could watch themselves as their beautiful words going across the screen as they came out of your mouth. No, that is not going to happen from the PREB. If you want to buy it yourself, you can, but we're not going to have that. On the issue of transcripts, though, so there's not going to be live transcripts with monitors, not that I'm paying for. On the question of transcripts, the Bureau is exploring two options. All right. One is the conventional option, where we hire an outside firm and they produce the transcripts and charge for them. And I don't know what the terms are as to whether there would be a single transcript that the Bureau pays for, which it then can share with everybody at no cost, or whether it would be something that each individual party has to buy. And I promise you, I'm fully aware of the problem of unfairness when some people have more rapid access to the transcript than others. I don't know that that's a legally constitutional problem, but we're trying to run a show here that's fair to everybody. So they're looking to that. The other option is AI, is AI summarizing the recording, which unfortunately produces something that looks like James Joyce's Ulysses, the final commentary. I'm just showing off. I didn't actually read it for the exam, whatever her name was at the end, which goes on for 5 pages without any paragraphing or punctuation, if I recall. And then somebody has to clean that up, but there needs to be an official transcript. Anyway, we're looking at those two things. Okay. And again, we will get an answer to you by mid-October. Okay. The present plan is for the evidentiary hearing to be held at the Bureau's headquarters. And I checked yesterday with my colleagues, that building does not have a spare room. In fact, I remember 10 years ago eating my lunch back in the some closet back there, but there is no extra room, so that's a problem. Also, there's only one little lunch counter downstairs, and without commenting on the quality, it's a long line. So that's a problem. Now, I did ask, and everybody internally smiled, what about the empty FOMB offices? And after people smiled, they said, maybe we can look into that. And one of our people is looking around the building to see if there's anybody who's vacated recently. And when I get that information, we'll share it. But right now, you need to assume that you're going to have to come up with some idea. And I recognize that's a problem. Like I said, we'll take Wednesday, Thursday, Friday. I'm sorry, Ms. Mercado?
If I may, is there any room for consideration on the hearing location? I know it will cost money, but a prior experience, it's a small place, the actual conference room, you've been there. So I'm really worried that we won't all fit, particularly since there are panels to incompete many witnesses at the same time. I have a good faith concern that we won't be able to actually accommodate all people in that room.
Yeah. Well, thank you. I appreciate your emphasizing that, and I'll make sure that I bring that back. I'm just thinking for a second. I don't know that the audience will last more than the first few days. I do remember there was a gentleman from he wasn't a bondholder. He was a, what do you call that, Mr. Brady? What do you call that service? There's a name for it. The insurer who insures the insurers. What is the name for that business? Isn't that
reinsurer?
Yeah, right. Thank you. I think he sat there the whole darn time. They seemed even to enjoy it. I also think it was his retirement job. As for the panels, I do remember being able to fit at least 6 or 7 people on a panel. You can forget about having multiple lawyers for a party sitting at the table. That's not likely to work. I'm not going to have 2 lawyers from one party at table and a lawyer for another party having to sit in the back. But I got you, Ms. Mercado. Thank you. I do see it as a problem. All right. Yes, we'll know the panel compositions ahead of time. I did say, yeah, we're taking Wednesday, Thursday, Friday off Thanksgiving week. Well, we'll get to the procedural schedule, but if everybody buys into my procedural schedule, that's what we have there. We talked about the panels. How much time allotted for cross-examination? Well, that's always a tough one, right? Nobody, I was once in a case back in 1991 at FERC where you had to give the judge an estimate and you had to live with your estimate. And somebody complained that I took 65 minutes when I had asked for only 60. And I thought that was a pretty good percentage for an overrun. But the judge didn't get mad. He wasn't going to say anything, but it still stings. No, it doesn't. What we're going to have to hope is that the cross-examination is well prepared. Frankly, and some lawyers aren't going to like this, but by the time the PREP consultants get done with their questions, there's not likely to be a lot left. Our job is to try to cover everything. So that what stinks for you is you have to prepare and then you don't get to show off that much. But I don't know that I want to assign actual times. What we're going to have to do is have a process, which is normal, is well before the hearing, get a list of everybody who wants to cross-examine whom, create a sequence. So there'll be a whole sequence, and we're going to vary the sequence so it's not always the same person going first. And get estimates from people ahead of time. I recognize that you can only guess. It depends, the person answering can take twice as long or half as long. It all depends. And then re-examine every day. That's what I did when I was a FERC judge. Every day we took a look at what we had. We made the best estimate we could about the next day so that we did the best we could to give notice. And that's all, Ms. Chambers. I don't know what else I could say to you right now about it, but I'm a pro like you and I know how it works, and we're going to do everything we can to discipline it and to give people notice. But yeah, there will be. Go ahead.
I was just gonna, suggest what you were saying, that it's good to have estimates. At least we can know when the people have to be here for the trial.
Yep. We're gonna do all the things, use all the tools. Heck, at 3 o'clock yesterday afternoon, I got a call from the lawyer in Richmond saying, Scott, you got to be here tomorrow, meaning today. I said, of all the days in September, because there were 25 witnesses listed before me, I figured there was no question about today. And it turned out a lot of people didn't want to do a lot of cross-examination. Okay, let's see. Yes, redirect. Start time is either going to be 9 or 9:30. And end time, roughly 5. I mean, I've been through this. Nobody can stand more than 6 hours a day of this. But if it starts to get tight in terms of time, we will keep people late because we don't want to go to the last week in December. And yes, we'll take some of us are getting old, so we're going to we'll take a break or two in the morning and a break or two in the afternoon, roughly at a halfway point. And as to witnesses, I guess this is my decision. I've always felt if a witness can talk to their counsel and come back more articulate, more clear, that's the way it should be. Somebody can always ask, what'd you just get from your lawyer? But I'm not going to prevent lawyers from talking to their witnesses. I just don't want it happening while they're being examined. You know that. So yes, you're going to confer ahead of time. You confer at the break. What I don't want is lawyers interrupting the questioning to say, wait a minute, let me talk to my let me coach my client before he answers the next question. You know that. We're not going to do that. But, we're going to try to be not excessively formal here, colleagues. Okay, let's just get the job done and get home for the holidays. That's all I have for now on this topic. Does anybody have any other? If you have any other logistical questions, email is fine for those. Don't put your answers in. Don't make it argumentative. And we benefit from that. And thank you, Luma, for putting this together. Okay, let's keep going here, says Ms. Vasquez.
Will the Energy Bureau set the panel compositions in advance?
Yeah, that'll happen in October.
Okay.
Of course. No, how else are you going to know who's going to show up and when to show up? Yeah, so, and go ahead, Mr. Brady, what?
Well, I wasn't sure if the parties themselves had a say in it, or if they were nominated by other parties, or who was the ultimate decision maker there? That's
me. Okay. Now, I don't mind putting out the proposed panels ahead of time. Look, it's from the witnesses. It's not anybody who's not a witness, right? The people who show up on panels will be witnesses or the PREB consultants who have filed expert reports. Okay, and yes, I will create the composition. I'll put it out ahead of time. If somebody thinks I've omitted somebody, that's exactly why I'll put it out ahead of time. You know how I operate. You get to work directly with me, elbow to elbow. Okay, Mr. Brady?
That's helpful. Thank you.
Okay, Ms. Chambers? Oh, you're muted.
I have one other procedural logistical item. And I know that you have ruled on the fact that there will be continuing discovery, but your ruling says that it continues through the end of evidentiary hearing. And my concern is during the actual hearing, they'll be very unable to be able to manage responding to discovery requests, prepping witnesses, and getting all our work done. I've never, normally it stops before the hearing. So I'm just suggesting that we set a date that we could do, before we have to start actually being there with our witnesses to end the discovery process, because I don't think it's practical.
All right. Well, you're asking for rehearing and I'm denying it, but you're giving me an idea here. So let me just work with you for a second. Again, what I don't want to have is somebody asking a question that's a good question, and I get a bunch of lawyers standing up saying, well, the discovery's over. So too bad the Bureau doesn't get to have the information it wants, because I can demand the information anytime I want, whether any lawyer likes it or not. So it really, in a sense, doesn't matter. But what I think, and I have warned everybody, don't use this looseness on my part as an opportunity to be loose on your part, okay? Because I don't have to say yes to the request. So let's put it this way, Ms. Chambers, and I don't know that I need to put this in an order. There's going to reach a point in time where nobody has a right to discovery unless I grant it. Okay, and at that point, I'm going to try to find out, what's realistic here. And I think that's really the way to accommodate what I need and what you need. Okay, so we're not going to put somebody in a position where it's impossible to answer a question because somebody thinks they have some right. So maybe I need to write that down in a careful way and put that in an order that discovery is permissible on my say-so after a certain point. And there better be a darn good reason for it. Does that make sense to you, Ms. Chambers?
Yes, because I like to, during the hearing, be able to
All right.
focus on giving you a good record.
right. All right, well, then you get the assignment of giving me some good language I can use, okay, since you came up with this bright idea. And just put it in an email in the next week or so and send it to everybody, and I'll make a ruling so that we have clarity on that. So thank you. What you've done is you've helped me clarify that I'm not creating an unconditional right, and I'm giving them a little more clarity as to what the conditions are, namely my say-so. Okay, and we're going to take into account inconvenience to the parties and disruption of the hearing and disruption of witnesses and counsel's ability to do their jobs at the hearing. Okay, Ms. Chambers, thank you. All right, you and I, we can always work things out. That goes for you and everybody else. Okay. Does anybody have a serious objection to my proposed revised schedule? All right, we're lucking out today. What's left on our agenda? Oh no, one more page. Okay, let me switch the orders of 5 and 6 so that people who don't care about Hunetta and PREPA's dispute can leave. Like I say, there's a lot of orders, and sometimes I try to get a bunch of stuff done in one order, and then it occurred to me that, well, maybe people are keeping a filing system that makes that complicated. And it's not like I'm systematic about it. Does anybody have a strong view one way or the other, or they don't care, or they don't read the orders, or it doesn't matter, or what? Ms. Does anybody have any concern, any opinion? All right, then I'm just going to roll along like I'm rolling along. If a couple of things all show up at the same time, you know, it saves Sonia time and it saves me time to put them all in one order. But if I think something really deserves, is at risk of getting lost, right, in the rush to things, and I will put it in its own order. That's kind of the way I think about it. Okay? All right. Then anybody who doesn't want to hear Ms. Vasquez and Ms. Valle talk to me about their discovery dispute, they can peel off. And I thank everybody. This has been a long meeting. I thank everybody for their patience today and their helpfulness.
Thank you.
Oh. Whoops. Did I lose? I already lost a few people. Too late. I have one more thing. I'll bring it up the next time. Okay, let me get my notes in order here. Ms. Vasquez and Ms. Valle.
Mr. Hempling, could we get a 3-minute break?
Of course.
Before we move on this part?
Yeah, let's make it 8 minutes. Why don't you come back at 5 minutes after 4? But I'm going to tell you, I think I have a way to make this very short. Okay, but come back in 8 minutes, 4:05, please. Thank you. I'm going dark.
Okay. Thank you.
Thank you.
Okay, could you, Gerardo, please take down the welcome screen? Thank you. All right, Ms. Vasquez and Ms. Valle, let's have you turn your video on and your audio on, and let's get this job done. Ms. Valle, are you there?
Yes, I'm here.
Okay. Now, were you able to get your controller here?
Yes.
Okay, well, we're going to get to this person. And what is this person's name again, please?
Juan Carlos Adrover.
Well, how should I refer to him? What is his last name?
Adrover.
Okay. Why don't you, I'll get it if I got the spelling. Give me the spelling, please.
It's ADRO, V as in Victor, ER.
Adrove.
That's
Is
correct.
that right? Adrove?
Yes, with an R at the end, but I think that's fine. That works.
Oh, Adrover. Adrover.
That's correct.
Okay.
Exactly.
Adrover. Okay, thank you very much. Sorry for my ignorance. Now, I want to go down the list for a minute. I've got the questions here. We're going to get this solved today, all right? And so that Ms. Valle doesn't have to file anything tomorrow. That's my whole point. Got enough paper around here. In fact, let me get Mr. Adrover up here first.
Yes. Hold on one second.
Okay. And Ms. Vasquez, I'm going to give you all the time you want to ask questions, okay? Let me see if I can get a feel for the situation first. Is that okay?
Yes, thank you.
All right, thank you.
Okay, we're here.
Mr. Adrover, ¿cómo está?
Hola, todo bien, ¿y usted?
Okay, thank you. Can you hear me okay, sir?
Yes, sir.
Okay, thank you for your work and for your attendance today. I'm sure you're a very busy person. I want to ask you a couple of questions about this. I mean, what I gather from your response to Genera is that this energy sector reserve, first of all, you have nothing to do with it.
Nope.
You don't have any, how did you even learn about it?
Newspaper.
Okay. The same newspaper article that Ms. Vasquez cited?
Yes.
Okay. Did you ever talk to your CEO about this matter?
Yes.
She know anything about it?
Nope.
So the legislature goes and puts aside how much here? $683 million for your use and doesn't tell you anything about it.
Sorry, who didn't tell me anything about it?
I'm sorry, let me say it again. My understanding from what you just said is that the legislature makes a decision to make $683 million available for needs that PREPA has and doesn't say anything to PREPA about it.
Exactly.
Well, before I do anything else, Ms. Vasquez, do you have any questions of the gentleman? And again, Mr. Adrover, I don't want you to answer any questions until your counsel has an opportunity to tell me whether she's comfortable with the question, okay? I know you are going to be very polite and want to answer right away, but I want you to give your lawyer a chance to talk to me first, okay?
Roger that.
All right. Okay, this is what I suspected, Ms. Vasquez. I understand why you asked the question. I have it too. But go ahead. Do you have anything you want to ask the gentleman?
No, before asking him anything, I think this is a question that is not limited to PREPA's controller. Obviously, the existence of this reserve begs the question of whether anybody at PREPA had any knowledge about the existence of said reserve. Like the article mentions that it is in a trust in the government, but it's just really incredible that an account of this nature, right, that has the possibility of uses for both pensions and emergencies and other matters that have to do with the energy sector, that PREPA doesn't know anything about it. That's all we're asking. And I think it's not an issue that's limited to PREPA's controller.
All right, well, here's my reaction to what you're saying, Ms. Vasquez.
Mr. Hempling, if I may.
One second. I'm just trying to fashion what I want to say to Ms. Vasquez, and don't go too far, Mr. Adrover. There's no CFO at PREPA, right? Ms. Valle?
That is correct.
So,
not at the present moment.
So what I have right now, and I didn't put Mr. Adrover under oath because I don't think I need to, but he's telling me that he doesn't know anything about it. His CEO doesn't know anything about it. Now, if you distrust the answer, you're welcome to distrust his answer, but that's not a discovery dispute. Okay, and there's nothing I can do about it. That's what I want to make sure you understand. I'm sympathetic to your desire for an answer. I'm curious about it too. But the fact that you don't like the answer or don't trust the answer, and I'm not suggesting that you have grounds or don't have grounds for that, it's not a discovery dispute. And there's nothing I can do about it. Now, I don't know what you can do about it unless you want me to subpoena him or put him under a lie detector, but I'm not going to do that. So that's why I think this is not going to go anywhere, Ms. Vasquez. Now, you're welcome to argue with me, but that's my reaction at the moment. Now, I do have some interest in some of your other questions. But first, right now, I don't know what we're going to do about this other than just nothing. But go ahead, ma'am.
Well, does PREPA CEO know anything about this reserve?
Well, he just told me that she doesn't. He told me that, right? Now, I guess you could ask that question and they could go get the answer, but you talked to her about it, right, Mr. Adrover?
Yes.
All right. Well, tell me about the conversation. Would you come in? Hey, ma'am, I read in the newspaper today that we're getting $638 million. When can I start writing checks? And she says, what on earth are you talking about? Is that how the conversation went?
Pretty much.
Okay. I mean, what do you want me to do, Ms. Vasquez?
Mr. Hempling, if I may, I think I can bring a solution to this matter.
All right. One second. Ms. Vasquez, what do you want me to do about this?
I think at least PREPA should inform PREP if they do have any knowledge about this account. This would definitely affect the calculation of the rate case. If there are funds available for pensions and for the emergency reserve accounts, I think we all should know about it.
All right. Well, I want to know about it because I'm the one advising on the darn rates. And if there's going to be $638 million, that's going to be great. But what I'm being told by the gentleman is that he doesn't know anything about it. Ms. Valle, what?
What I wanted to add is that's our response at this time. The situation could change. Maybe in the future we can get information and we will be more than willing to share it. There's no, contrary to the statements, PREPA is not being intentionally evasive. It's simply sharing the information it has at the moment.
All right, that was my reaction to the whole situation. So let me make it very clear to you. I am putting you, never mind Hineta, I am putting you under a continuing obligation to bring the information forward about the $638 million if and when you have it, okay? And I would like you to do what you can to find out about it, but I don't want to be ordering the CEO to start making phone calls to whoever is in charge of this money to find out about it. But she should know that I'm pretty interested in this money because I don't particularly want to get a surprise in late November that there's a whole change to the revenue requirement because now we have access to this money. Actually, I wouldn't mind that. I should have said, well, happy to have the money, but I'm worried about a disruption to the case. Ms. Vasquez, I don't know what else we can do about this right now.
No, I think if they have a commitment to inform when they do know about this access to these funds, I think it's important for everyone to know.
You have
Okay.
it.
Okay. I mean, what I want to think about for a second is whether there's something, this is out of my outside of my authority, but whether the commissioners, whether the Energy Bureau ought to do something in terms of contacting the relevant government agencies. Now, do you have any information, Mr. Adrover, about? Wait, did I just lose you?
No, we're here.
Do you have any information about who in the government has the power to to make decisions about this money?
I believe the Secretary of Treasury Department, Puerto Rico.
Well, what is the basis for that belief? The newspaper article?
Yes.
There's no other basis for that belief?
No.
The newspaper article actually mentioned the Department of Treasury, I think, did it not?
Yes.
Okay, that's all you know. You don't know anything more about it.
Excuse me, Mr. Henry, it's actually the Office of Management and Budget, and his name is Orlando Rivera. It's not the Treasury.
Okay. OMB, well, to go back and look at the article. Thank you, Ms. Vasquez. Don't take this the wrong way, Mr. Androver, but if I read in the newspaper that somebody was putting aside $638 million for me, I'd give him a phone call, right? And sort of try to find out, well, I just filed a darn rate case and maybe this would change it. And have you or the CEO made any effort to find out when this money would be available, for what purposes, sir?
Yes, clarifying. Yes, I said the Treasury Department because we did reach out to them. We are waiting for their answer.
And when you say you reached out to them with what kind of question?
Exactly that we did not know what is this all about, and we needed the clarification because Genera was reaching out to us, and we did some due diligence, and they said that they are working on an answer for us.
Okay. Is this, Ms. Valle, is this a letter, this is a document, two documents, one written from PREPA and one written back from the Treasury Department? Two documents?
I Mr. Adrover can confirm, but I don't think so. You mean the communication?
Yes. It was informal communication.
Okay. Have there been any other communications beside the one you just described?
No.
Okay. You might have put that into your answer, not that you were evasive, but probably if you'd put that in your answer, you might have, probably would have given Ms. Vasquez a little bit more assurance that this thing didn't just sort of end up, in the paper and nothing had happened. So that was the only communication, basically?
Mm-hmm.
All right.
Yes.
Well, I would appreciate it if you would, using the Discovery platform, Ms. Valle, keep Ms. Vasquez informed of efforts in progress. And I'm not asking you to do I don't want you to put anything in there that you consider privileged, but right now this sounds like ordinary government activity. And I don't want to overwork you either, okay? So it's not like if you forget to tie your shoelace one day and put it in the, you know what I'm saying. Just keep us informed of it. Ms. Vasquez, I'm doing the best I can here for you, okay?
I appreciate it.
All right, well, I'm sure I don't agree with you on the evasiveness of it. That was my reaction to this. And I think that they just, surprising, but not non-credible. So they don't know. I'm looking at your question list now. I do think, Ms. Valle and Mr. Adrover, that Ms. Vasquez's set of questions are very interesting ones, the answers to which you would want to know yourselves. So you might want to use her list as a, I don't want you to be calling them up and bugging them, but you want to sort of do the best you can to get answers to these questions. Is that fair, Mr. Adrover?
Yeah, of course.
Okay. Do you have anything else, Ms. Vasquez, today?
No, thank you very much.
Well, thank you. Let's try to keep this thing friendly. All right, everybody relax. We've got a lot of work ahead of us, and we have all a common desire to help our fellow citizens in Puerto Rico. So let's try to keep the temperature down and the smiles up, okay? That's all I have. Anything else, Council? All right, thank you for your patience. It's been a long afternoon, and I've learned a lot. So Mr. Brady, what?
Oh, I was just going to ask that to the extent there is any follow-up on this information request, that it be made available to all parties, which I assume it would be through the platform.
It's going to go through the platform, and I don't know that I want to ask them to email everything. People get enough emails. Just keep an eye on the platform. And Ms. Chambers, I'm looking to end this meeting pretty soon. What do you have, ma'am? You're muted.
I just had a quick question. I'm not familiar with the government of Puerto Rico as much as you are, but you mentioned that it was OMB that was the person in the newspaper article, and I think Ms. Valier said it was OMB that had the information, but you contacted the Treasury. Are they connected? Is OMB part of that? I don't know. I'm just trying to figure out.
It's two different
Yeah.
government departments. So yes, if pursuant to the newspaper article, it is OMB, but definitely if it's something that PREPA understands maybe under the Treasury Department, which could be another department, they're asking them. But the newspaper article mentions OMB, and it's a different agency.
I just wanted to make sure my notes were correct. Okay, thank you.
Okay.
Yes.
Thanks for your patience.
Well, thank you for everybody. Long day today. Thank you for all your help. And Mr. Adrover, thank you for your work on behalf of the citizens. I know it can't be an easy job, and I'm not sorry to have bothered you today, but I hope we don't have to bother you too many more times. And we thank you very much. And with that, we're now adjourned. Thank you, colleagues.
Thank you.
Thank you.
Thank you.
Thank you.